because therefore they say that every employable person, once he understands the consequences, once he understands what can constitute sexual harassment, also women understand that, listen, you can't misuse the law, because if you misuse the law, action can be taken. In that sense, the government has tried best to its own ability to try to balance the concerns of all parties. There is no need for sensitization, as everybody knows what is sexual harassment. I gave you an example of what can constitute sexual harassment. A sexually colored remark, again, is also sexual harassment. And I'm saying, so you would possibly find so many times when we possibly are, like in this, in driving on the road, and you find somebody driving not so well, and then you'll possibly just make a comment, "Ladki gaadi chala rahi thi." So I'm saying these kind of comments are made by people in everyday life. Again, I'm not saying that you make a comment like this and the woman is going to jump and make a complaint, but it may amount to sexual harassment complaint in case you make these kind of comments repetitively, because it may offend somebody. The law can be misused by women. There are enough checks and balances, and I'll take you through a few of the salient features of the law where we believe that this law cannot be misused. It's only if the committee is unable to do their job properly can this law be misused. Otherwise, this law cannot be misused. This law is unfair because it's not gender neutral. So again, if you look at all the countries in the Indian subcontinent, you talk about Pakistan, you talk about Sri Lanka, you talk about Bangladesh, you talk about Nepal. All of these countries have similar laws, but they are only for protection of women. So when people say that Indian government have to calm down, they're making all these stupid laws. Pakistan got the law in 2010. Bangladesh got the law in 2009. Nepal got the law in February 2015 after us. So in the entire Indian subcontinent, most of the countries have laws for protection of women only at this point of time. Obviously in the West, Europe, US is gender neutral. So I think so, nothing stops the government from making it gender neutral at a later point of time. I think so, with more and more women empowerment coming up, at some point of time women will sexually harass men. It doesn't happen today. And as and when they do that, hopefully government will take cognizance of that and then make it gender neutral. We are not saying that men don't get harassed. We are here talking about men getting sexually harassed. So I think so that's the difference. Men getting harassed by men could still be a reality, but men getting harassed by women, I don't know of too many people, or possibly I know none. So that's another thing. Again, a lot of people still think that Vishaka guidelines, so when you talk to a lot of people in HR, they still talk about Vishaka guidelines, Vishaka Supreme Court. From the day this law has come into being, Vishaka guidelines is no longer good law, because Vishaka guidelines actually came in because of a gruesome incident which happened in 97. So there was actually a rape incident which happened of one of the government employees in 97, and she was actually opposing child marriages, because of which she was gang raped, and Vishaka, which is an NGO based in Jaipur, took it up in the Supreme Court as a PIL. And at that point of time, the Supreme Court actually looked at and scanned the entire law of the country. It found that there was no domestic law to take care of such kind of situations at workplace. It also found that the women had the right to a safe and working environment. They had the right to make their own choice about what they want to do as a profession. And even India was a signatory to the UN Convention for Prevention of Discrimination of Women. But despite that, the government had actually not come out with any specific law. So in 97, the Supreme Court said that till such point of time the government does not come out with a law, I'm coming out with a judgment which will be the law of the land. However, since there were no consequences of not complying, that law did not see too much of action on the ground. There have been several times where the Supreme Court reminded all the state governments to implement the law, but it didn't happen much. Now in this law, there are several severe consequences for not complying in case you don't comply. So I think so, therefore, we are seeing more and more organizations coming forward and complying with this law. And then what you'll possibly find is that a lot of organizations have created an anti-sexual harassment policy, and they have a committee in place, but they're not even telling people that they have a committee in place or they have a policy in place. At the end of the day, this entire law is about behavioral change. Unless you don't sensitize people about what constitutes sexual harassment, what is acceptable, what is not acceptable, you will never be able to prevent. The idea is eventually people will know about the law, and this law not only affects you in the corporate world, it also affects you in private life, because under this law, even domestic helps at home. In case they want to make a complaint against the owner, if they believe that they've been harassed by one of the owners of the family, they can actually make a complaint to the local complaint committee. So this is actually a kind of a very overreaching law which kind of gives protection to all women. So basically salient features of the law. I'll just take you why this law is kind of try to take a balance of all the concerns of all party. Under this law, the woman has to make a complaint within 3 months of the date of from the date of incident, and if 3 months from the date of last incident in case there are series of incident. This period can only be extended by another 3 months in case she has some valid reasons why she was unable to come within the time. So earlier, the woman could actually come and make a complaint after 3 years as well. So this is again to make sure that it is not possible for her to make a complaint the next morning, but she is given reasonable time to get her composure, and if she believes that she's been harassed, she has to make a complaint within 3 months. Confidentiality, one of the very important features of this law. This is the first law which actually mandates that the organization and the people involved have to keep the thing confidential. So the identity of the persons, the accused, the aggrieved woman or the witnesses cannot be disclosed to anybody. What transpired in the internal complaint committee cannot be disclosed to anybody. Time-bound redressal, the inquiry has to be completed within 90 days. In case the complaint is proven to be true, then the monetary compensation is payable by the person against whom the allegation is proved. Now this again is like an insurance policy from the organization standpoint, because once you've done whatever was mandated in the law, you do not have any liability. Principles of natural justice. Whether we like it or not, in this the initial burden is actually on the woman to prove the complaint. Because principles of natural justice says that whoever makes the allegation has to prove the allegation. Burden of proof. It is out here you have to prove probability. So it is basically it's better for a woman to come and approach the internal complaint committee, because out there you just have to prove probability. Whereas if you go to the police, you have to prove beyond reasonable doubt. So therefore, we don't believe that women will go to the police. First, because obviously you're not going to have any confidentiality, it will not be time bound, and secondly, obviously the burden of proof is much higher. Punishment for false and malicious complaint. In case somebody is misusing the law and the committee comes to the positive conclusion, then she can be actually in for trouble. And despite all of that, supposing the recommendation comes against the person, if you're not happy with the recommendation of the internal complaint committee, you can actually go and appeal it before the industrial tribunal. There is also provision for conciliation. At times what happens is basically, because of Hindi movies, you typically people tend to think that unless you don't woo the woman, she will not agree. So you'll ask her out for once, she says no, you'll keep repeatedly asking her. At some point of time she gets fed up and she makes a complaint, not because she wants an inquiry to happen, she just wants the bad behavior to stop. So you have a conciliation provision, you made a complaint but you can still reconcile. So is the case of interim relief, that you made a complaint but you don't want to face each other. So there is a provision for interim relief where either of the party can be transferred to another location, or possibly you can be given additional leave. Quid pro quo and hostile work environment are actually types of sexual harassment. What is more important is basically unwelcome. Whatever is unwelcome to the woman is basically can constitute as sexual harassment, and it will be perceived from a reasonable woman's perspective. And intent versus impact. As I said, the intent is not as important as the impact. Okay. And basically the intent will be looked into for the purposes of what kind of recommendation should be made. So in case it was something which was innocuous, possibly the recommendation will be a warning or something, but if it is something persistent, then obviously you are in for bigger trouble. So the obligations under the law, I actually said, forming an anti-sexual harassment policy, displaying posters, creating internal complaint committees, sensitizing and training employees committee members, making disclosures in the annual report. All of this, whatever the obligation there of the internal complaint committee, the organization is responsible to provide all the support. And what can be the consequences? In case you don't, for the organization, in case you are not complying with the law, it's a criminal offense for the management. The fine is up to 50,000 in the first instance. If it is a repeated offense, double the penalty and closure of business. There have been instances, because now it's become a criminal offense also. One of the biggest financial institutions in the country, they did not have an internal complaint committee etc. in place. In that kind of a situation, the woman made a complaint against the management as well. An FIR was filed against the entire management, because there is a concept called abatement, that if you, by law you're required to do something which you don't do, then you have indirectly abated the offense. So there have been instances where an FIR has been filed against the entire management, and one company was fined 1,68,00,000 rupees for not complying with this law. That was by Madras High Court. So these are some examples. If you don't comply, what can be the consequences? I've basically said these are our thoughts. I think so I'm running more on time. So this is actually more about us. If you have any questions, you have the book. Our contact numbers are there. You can feel free to call us. Thank you so much.